Good afternoon, everyone. My name is Nathan Stelter, president here at the Stelter Company. And thanks as always for joining us for a very special webinar today. And I'll get to introducing our speaker and our guest today in just a minute, but want to say a couple things about the webinar series I know many of you are familiar with, but here at Stelter, we're passionate about helping nonprofits discover new opportunities. Hey, there it is, for growth through asset-based giving and stronger donor engagement. We're proud to help foster connections across the entire nonprofit community through webinars like these, bringing amazing experts like Kent from around the country to share ideas, lessons learned, and offer practical guidance fundraisers can put to use right away. Today is actually our second webinar of the 2026 webinar series, where we've got a little slow start, but we have a ton coming down the pipeline. Including some of our great presenters and special guests like Kent this year, Eddie Thompson from Thompson Associates, who's given a couple talks for us, Nathan Chappell, who's doing some great work in the world of the AI. He's the currently Chief AI Officer at Virtuous. Nicola Lawrence, who not only serving as Vice President for Individual Giving at Phoenix Children's, but is this year's CGP Chair, will be sharing some insights. Michael Mitchell from the fundraising agency, as well as our Stelter strategists and others, looking at and taking deeper dive on the Giving USA report. So look for your personal invitations. They'll be coming into your inbox each month. And looking forward to seeing you. If you have missed any of our webinars, either the one earlier this year or any in previous years, you can always access those at stelter.com/webinars. But to get back to the reason why you're here today, it's my pleasure to introduce a dear friend of mine, an amazing individual, Kent Weimer. Kent is the retired, although you wouldn't see it, as he's busy all over the place, traveling and speaking and doing a lot of great work. But he is retired director of trust and estates and gift planning from the Parkland Foundation in Dallas, where he worked with donors and advisors to make estate gifts, create endowments, and make donations with other with assets other than cash. He's worked for over 40 years in this great industry of ours in a variety of types of organization, from community-based healthcare like Parkland to higher education, international healthcare, and social service organizations. He's been active for over 25 years with our own National Association of Charitable Gift Planners, where Kent and I had a chance to serve together, but also on the local level when he was in Chicago and more recently in Dallas. He was the past chair, did an amazing job for our national board and treasurer, and has served on the board of governors locally at the Dallas Estate Planning Council and as a volunteer facilitator and advisor for local CAP study groups. Kent is a gentleman who makes these topics enjoyable and interactive, and I'm excited to have him on our presentation today. If you get a chance to see him in person, please do, because he's always a joy. So Kent, I'll hand it over to you.
Thank you, Nate. I really appreciate the opportunity to be here today. What a pleasure to have you folks out there in the ether world who are joining us for this. So today I'm going to talk about tax law and ethics and make it fun and entertaining. So buckle up and come along for the ride. Before we get started, there's some premises that are very important to me and that will be themes throughout the entire presentation. As a charitable gift planner, I have a duty of care to my donor. Donor intent is sacred. If a donor gives us money for something and says, this is what I want you to use it for, we have both a legal and an ethical obligation to do that. If we're unwilling or unable, we shouldn't take the gift. As a nonprofit gift planner, I also have a duty of care and a fiduciary duty to my institution. And sometimes that's to protect my institution from ill-informed or bad donor intent. Well-written gift acceptance policies that are current and reviewed often and used will help you when you're confronted with unusual gifts. And well-written gift acceptance policies that are followed will help save the day and be your best friend. And also, we're going to talk a lot about tax law today, but remember, fun and interesting. Um, I think as fundraisers, we have an obligation to have at least a basic understanding of tax law and how gifts might affect a donor and their tax deductibility. Today, we're going to go through a lot of case studies. This whole program is based on case studies. Some are ripped from the headlines, some are tax court cases, and many of them are ones that I've dealt with in my 40-year career. And in a lot of the instances, the donor's tax deduction has been jeopardized. So having an understanding of tax law can help your donors and help you and your organization. So let's get started with our first case. In the middle here is Dr. Robert Zimmer. He's the president of the University of Chicago, and he is flanked by Thomas and Timothy Pearson. The Pearson brothers were here. This photo was taken at a press conference where the Pearson brothers were announcing a $100 million gift to the University of Chicago to create the Pearson Institute for the Study of Global Conflict. What a worthy cause in this day and age. What I want to know is why in this picture do the Pearsons look so unhappy? Could it be a foreshadowing of the lawsuit that they would file against the University of Chicago claiming that they weren't living up to their gift agreement? Well, let's take a look at this and see if there were any red flags. Let me list them for you. First off, none of the Pearsons had ever attended the University of Chicago. They had come up with this idea for the Institute and were shopping for a home for it. And they finally found the University of Chicago was receptive to the conversation. Second, they had a history of suing nonprofits for not living up to the terms of their gift agreements. One of all places was the theology school at Northwestern University, claiming that they weren't living up to the terms of the gift agreement. Maybe they just don't like Chicago-based institutions. I don't know. And third, the gift agreement, rather than being a standard gift agreement, was written by their attorney and read more like a mergers and acquisitions contract than a typical gift agreement. I'm guessing that Dr. Zimmer is going to be far more careful of the gift agreements that he puts his name to in the future. The good news is this went to court. Attorneys made a lot of money off of this case, but the good news is they finally settled and the Institute is thriving and still operating at the University of Chicago. So just for the fun of it, let's talk about the IRS. The old way that the IRS would challenge a deduction, if they thought maybe the deduction was overstated, is they would, if it was a non-cash gift and there was an appraisal with it, they would get their own appraiser, and their appraiser would come in with a value less than the donor's appraiser, and it would end up in the tax court. And usually the tax court split the baby in the middle and both parties went away unhappy. The donor didn't get the deduction that they expected, had to pay a little more in taxes. The IRS got some money, but not all of it back. And so nobody really went away happy. Now, the new way that the IRS is challenging deductions and being much more successful at. In the paper that Jen mentioned, there's a really good blog from an attorney that talks about the new way that the IRS is challenging deductions and how they're being successful. So now if the IRS thinks a charitable deduction is overstated, They look at the paperwork. They look at the receipt. If there's an appraisal, they look at the appraisal. And if it goes to the tax court and they determine that the paperwork is not adequate, no deduction at all. And the donor walks away with nothing. And if that doesn't work, then they'll go back to their old way. So let's talk about the paperwork. Receipts are embedded in the tax code. This is the law of the land. The tax code tells us that a charitable receipt has to be contemporaneous written acknowledgement. And contemporaneous means that the donor has to have the receipt in hand when they file their taxes. And so it has to list the charity's name, what's the date of the gift, if it's cash, what was the value of the cash, if it's property, a description of the property, and a statement about goods or services. And it amazes me to this day. I get receipts for donations that I make that don't have the statement about goods or services. The receipt should say no goods or services were provided in exchange for this gift, or if something was provided, maybe a meal, the donor received a meal valued at $100 in exchange for this gift. Appraisals are addressed through treasury regulations. They're very specific, they're very detailed. They go into a detail about what makes an appraiser a qualified appraiser, and it goes into detail about what makes an appraisal a qualified appraisal. There are 11 specific elements that the Treasury regulations say have to be addressed in an appraisal. And the appraisal summary is the Form 8283, which everybody's familiar with. That's signed by the donor, the appraiser, and the charity. And the charity isn't attesting to the facts of the appraisal. They're simply attesting to the fact that they received whatever they said that they donated. And many of you know Jonathan Tidd, a very well-respected attorney in the nonprofit world. His firm only represented nonprofit organizations. And at a national conference once, in a presentation he was he was talking about qualified appraisals. And he said, in his opinion, he had never looked at an appraisal given to him by a nonprofit he was working with that in his mind met the strict rules for being considered a qualified appraisal. That's a little bit frightening. And he made the suggestion that if you get an appraisal, you send a letter to the donor thanking them for sending you the appraisal and recommending strongly that they seek legal advice to determine if the appraisal meets the Treasury regulations for being a qualified appraisal. And ever since he made that suggestion, I had started doing that. And, typically it's going to be the CEO or the CFO maybe who signs the 8283 on behalf of the nonprofit. And so in our procedures, I changed it that appraisals had to first come to me so I could review them and send this letter to the donor and look it over and see if I saw any issues. And then I would hand it off for signature. So let's jump into some tax court cases. Miss Villarreal was an animal lover. So she decided she was going to start animal shelter where she rescued animals. She was the sole officer. She was the sole employee, non-paid. She just did this out of the goodness of her heart. And the way that she supported the nonprofit is she would write a personal check from herself to the nonprofit, and that took care of all the operating expenses, buying the food, caring for the animals, the health care, so on and so on. What she failed to do was write herself a receipt for all of the donations that she sent to the nonprofit. And this, she was audited, and this went to the tax court. She had her bank statements, she had copies of canceled checks that she could show that she had made these donations. But if we go back to what the tax code says, there has to be that written receipt to substantiate a deduction. So the tax court said, no deduction at all. You didn't follow the law. And this is kind of a sad case. She wasn't trying to do anything wrong. She was just misinformed and didn't know what she had to do. Mr. Ney made a contribution of a non-cash asset to a charity, and he had an appraisal done. And according to the Treasury regulations, the appraiser would have met the rules for being a qualified appraiser. He was audited, and it went to the tax court, and the tax court found out that the person who appraised this item was also an employee of Mr. Ney, and they said no deduction. He's not a qualified appraiser because of the prior relationship with the donor. The Odies, this is a fun one. The Odies claimed that they made a donation of over 20,000 specific items to Goodwill Industries. Over the course of a year, they went to this Goodwill, many trips, donating all sorts of stuff. And they claimed a deduction of $142,000 and change. They claimed that they had donated 115 chairs, 3,000 books, 1,040 items of boys' clothing. And so what happens when you go to Goodwill or Salvation Army and donate a box of stuff? They give you a receipt that's blank, has the name of the organization on it, and a bunch of blank lines that it's up to the donor to fill in. So to substantiate their donation, they used TurboTax to determine the value. They had a very comprehensive spreadsheet that had every one of these 20,000 plus items on it, and with the value of it from the TurboTax software that they were using to determine the value. So what is it, do you think, that they were missing? They were missing a qualified appraisal, because we know that if a donation of stuff is worth $5,000 or more, that they have to have a qualified appraisal. This went to the tax court, and the tax court said, you don't have an appraisal, so you get no deduction. They were allowed a deduction of $250, which is what you can deduct without substantiating it, and then given a penalty of $6,500 and change, because the IRS issues a 20% penalty when you do things, for example, like not substantiate your donation. So it raises the question. Let's say you're an art collector and you donate a bunch of pieces of art to your local art museum. And you claim that, and you do this several times over the course of the year, and you claim that each piece of art was only worth $4,999, and therefore you don't need a qualified appraisal for it. Well, the IRS looks at things in a tax year, and they would consider that one donation and bulk it all together and say, yes, you do need a qualified appraisal. So I don't know if that was the situation with the Odies, where they thought each time they went, the value was less than $5,000. So they didn't need the appraisal, but the tax court obviously said, yes, they did. I
Hey,
used to work at Lake Forest College up in Lake Forest, Illinois, great little small liberal arts college. We had a chemistry professor who was very beloved and very generous to the college. He'd made lots of donations over the years. One of the things that he donated to was they had this fund in the chemistry department, and he would donate to that. It was kind of a slush fund where they could do things that were outside of the budget. He was the chairman of the Department of Chemistry. He created the fund and he had the expenditure control over the fund. Now, to my knowledge, he was never audited about this. But when I found out that this was going on, I realized that if the IRS ever were to audit him and take a look at this, that they could very likely claim that this was a private benefit instead of a charitable organization and not allow his deduction. So I advised him accordingly. And if we were in person, I'd ask you how you would change this so he wouldn't get in trouble. And the answer that usually comes up is, well, have somebody else make the decision about how the money is spent so he doesn't have the expenditure control.
Kent, I'm going to go ahead and interrupt you. We do have a couple questions coming in, if that's
Oh,
okay.
good.
Okay. Kind of going back to the receipts and acknowledgement letters. Annie has a couple questions. So her first one is, can a written receipt actually be electronic?
Yes, yeah, the law does not say what form it has to be in. All it says is it has to be written.
Okay. And can the acknowledgement and receipt be combined together?
As long as it contains all of the elements that are required for a receipt, yes.
And if the receipt information is sent following the gift, does an end of year tax statement still need to be sent by mail?
According to the law, no. All you have to do is send the receipt once.
Right. So no
But
end
I
of
know a
year.
lot of organizations do send a year-end summary of, here's what you've done over the course of the year.
Sure. But it's not illegal to not do that.
No.
Okay. And then we have another person asking about acknowledgments. This is kind of a long question. So here we go. A couple renews their support with the IRA QCD from one of the donors' IRAs. Traditionally, we've sent the acknowledgement to the couple stipulating the name of the IRA holder in the body. I can't find anything showing that there's a problem with this on the IRS site. However, an attorney recently raised this issue because the acknowledgement went to both he and his wife. After sending out copious acknowledgments since 2006 for IRA QCDs, are we doing it wrong? Question mark.
Oh, and I'm not an attorney, so I'm not going to give legal advice here. But I think it's important. I think it's absolutely critical that when we get QCDs, that we acknowledge the donor and thank them. Obviously, we can't give them a receipt because they can't claim it on their taxes as a charitable deduction. But I think we have to acknowledge them. That's just good stewardship.
Okay. Going forward, do you have to include the fair market value amount if you include the total tax deductible amount on the tax letter?
So, so the fair market value, I'm assuming this might be for a gift of stock. If somebody donates stock to my organization, I simply state the facts. I say, on this date, we received 100 shares of NVIDIA stock from you. Thank you very much. No goods or services were provided in exchange for this gift. For a non-cash gift, it's up to the donor and the donor's advisors to substantiate the amount of the gift. It's not up to the organization to say what the value of the gift is. They only do that if it's cash. Cash, credit card, or check, we say the value. Anything else, we give a description.
Okay, someone else is saying to clarify, a donation of public stock does not require an appraisal. She believes that the donor has to file an 8283 for $5,000 or $500 plus, but does the charity have to sign the 8283?
And the person is correct. A stock gift does not require an appraisal. Um, I'm not an attorney. I don't know the answer to that. I don't know if we signed that 8283 or not. I don't recall ever getting one for a stock gift.
Okay, fair enough. I think we're going to go ahead and move on with the presentation, and we'll get to some of these other ones in a little bit.
All right, sounds good. When I was at Lake Forest College, we had some neighbors who had an architecturally significant house. They also had a fabulous art collection. They were alumni of the college, and he was on the board of trustees of the college. And there had been some conversations. He and his wife were interested in donating both their house and the art collection to the college when they were gone. They were going to do this through a trust. And their vision was that the house could become the art gallery for the college because it was literally right next to campus, so it would have been perfect. And all of the art would have been the college's art would have been displayed in this gallery, and maybe there'd have been some office space for the art faculty and so on. Absolutely fabulous gift. So I'm sitting in my office and I get an email from the president of the college. And he says, take a look at this gift agreement and let me know what you think. I'm meeting with the donor in half an hour for lunch. I can't make this stuff up. This really happened. So I read over this gift agreement really quickly, and it was a pretty standard gift agreement. And there was a clause in the gift agreement that said if within a 10-year period, the heirs, who happen to be three sons, if the heirs think that the college is not living up to the terms of the gift agreement, the house and the art collection will be returned to the heirs, the three sons. So now we're going to have a little pop quiz here to see whether you think that that clause in the gift agreement is problematic or if it's okay. So Jen's going to have you take the little poll here.
Yes, I'm launching it right now. So the question is there any problem with this gift agreement that Kent had just laid out for you? Yes or no? We're just going to give you a couple seconds to go ahead and answer. We're at about 60% of you that have answered the question so far. I'm going to let you continue for a few more seconds. So, in the case study that Kent just laid out for you, did you see a problem with the gift agreement? Yes or no? Okay, I'm going to go ahead and close the poll. And here is what you said. I'm not sure if you
96%. Yeah.
okay.
Okay, so I'm curious. Those of you who said that there's a problem, put in the chat what the problem is.
So here's when you can use the chat. Let me know if you're having a problem using it. Yeah, I'm sorry. The chat's not working. I was afraid this might happen. You can put it in the Q&A. So the question is, if you answered yes, there was a problem with that gift agreement, what did you think the problem was? So I'm going to go ahead and read some of these to you, Kent. Um,
Okay.
so we're saying would have received tax benefits for the gift, Teresa says. The vague language and restrictions on an outright gift. The gift is revocable. The donor still has control of the asset for 10 years. It's not a completed gift.
We're going to end right there. That's the
Okay.
exact right answer. I mean, all those others alluded to it. This is not a completed gift. So this family clearly would have been subject to estate taxes. They were a very wealthy family. So what would have happened upon the death of both of the parents is the college would have gotten the mansion and they would have gotten the artwork. And if the IRS looked at this, they wouldn't have allowed a charitable deduction for that because it was an incomplete gift. So the college has the house and the art. The sons are now having to pay estate tax on the value of the house and the art, which would have been several $1 million. And don't you think they probably would have found the best attorney they could find in Chicago to contest this and say, give us the house and the artwork back because this isn't working? So not only was that a gift with strings attached, that was a gift with a huge rope. Um, and when we talk about gift agreements are contract law. And to make a contract valid, you have to have at least two parties, and one party offers something, the other party accepts it, and something of value is exchanged for something else of value. So if we think in terms of nonprofit gift agreements, which fall under contract law, what are the things that would make a gift agreement binding? And the two things are consideration and reliance. So consideration, let's say Nate is going to donate $10 million to Parkland Hospital, and we're going to name a new clinic after him. It's going to be the Nate Stelter Clinic. That would be consideration. He's giving something of value, cash. We're giving something back of value, public recognition in that way for his gift. Reliance is a little bit different. So let's say Jen is going to donate $5 million to our capital campaign. And based on her pledge and the other pledges that we've gotten, we hire architects and we hire contractors and we start building the building. We're relying on Jen's gift to help us fulfill our need for paying the contractors and the architects and so on to build the building. And that's a legal term called promissory estoppel, where if she doesn't fulfill her pledge, that leaves us in trouble because we have to use her pledge to help make payments. So this is going to come into play in the next case. This is the Chicago Museum of Contemporary Art. Paul Oliver Hoffman and his wife Camille were art collectors. They had quite a substantial collection of their own art. Paul was a well-to-do real estate developer in the Chicago area. He was also on the board of trustees of the Museum of Contemporary Art, and in fact was the chairman of the board of trustees. And the museum was embarking on a very aggressive capital campaign to build a whole new museum campus to hold their art collection. So Paul and Camille made a $5 million pledge to the museum. And it was a typical pledge agreement. They said, we're going to give $5 million, and it had the payout details in it, and it was signed by both the donor and the museum. The problem is they never paid a nickel on their pledge. $5 million pledge, never paid a nickel on it. They called, he wouldn't answer their phone calls. They left voicemails, he wouldn't return their calls. They sent emails, they sent letters, they sent certified letters. They even at one point sent a limousine out to pick up Paul and Camille and bring them in to talk to the current chair board to talk about fulfilling their gift. Absolute radio silence. They responded to no communication from the museum whatsoever and never made nickel one payment towards their $5 million pledge. Now, you in the audience, you're the board of trustees of the Chicago Museum of Contemporary Art. You have a legal fiduciary responsibility to the institution. So we're going to go into the next poll here. If Jen, you'll pull that up, please.
Yep.
So you're the board of trustees. Are you going to sue the donor for this pledge or not? Yes or no?
We got about 39% of people. People are still answering it. So we're going to leave it open for a little bit longer while your answers roll in. It's closer than you might think. So we're going to let it be open for a little bit longer. We've got 60% of you who've answered. This is all anonymous as well, so don't be afraid to answer.
Go ahead and let's see what we've got so far.
Okay, we're going to end the poll, and here are your results.
This is pretty typical. The majority are not going to sue the donor. A little over a third of you are going to sue the donor. Well, they decided to sue the donor. The chairman of the board was Penny Pritzker at the time, and any of you familiar with Chicago know the Pritzker name. It's a family of billionaires. They own Hyatt Hotel, among other things. They're also very politically connected. She was President Obama's Secretary of Commerce. Her brother Jay is the current governor of the state of Illinois. And she said, Penny said in a press release that as much as we hate to do this, we have an obligation to the museum, to our new construction, to our other donors, and to the public at large, and therefore it's necessary that we sue this donor in order to get this pledge fulfilled. They were beat up in the press. One attorney said, if you're ever going to sue a donor, you better have a darn good PR campaign to go along with that, which they did not. And they were beat up in the press for having the gall to sue a donor. So it raises the question of fiduciary responsibility of a board. So is it the fiduciary responsibility to collect on every single nickel that's owed the institution? Or is it the fiduciary responsibility to the broader philanthropic community in which they're operating and they're standing within that community. And that answer, there is no answer. I mean, that has to be done individually. So, all right. I got a phone call. I work for Lions Clubs International Foundation. And person on the phone said, "Boy, do I have a deal for you." So immediately the hair on the back of my neck kind of starts standing up when a conversation starts that way. He said, I'm in a business partnership. Me and my partners own a bunch of apartment buildings. We want to donate one of our apartment buildings to Lions. You can sell it and then use the cash for the wonderful work that you guys do. And to make things really easy, I've already got a guy who's willing to buy it, and we've negotiated the terms of the sale. So all you've got to do is accept this property, sell it to my guy for the price we negotiated, and you'll make some quick cash to put to use for Lions. So here, if this was somebody answering the phone other than me, who understood that this was a prearranged sale, and that if this were questioned by the IRS, he would not get a deduction for it. We'd end up with the building. He'd end up not getting a deduction and having to pay the capital gains on the increased value of the apartment building. If some major gift officer answered this phone and thought, "Oh my gosh, I got a quota to meet, I've got metrics to meet, I've got goals to meet, this is a great deal, this is going to be some easy cash in the door." That's why I say that people, all fundraisers, should have some at least basic understanding of tax law, because the organization wouldn't get any trouble, but the donor would. And who's the donor going to be mad at? All right. Let's look at time here and see. All right, this is a good one. We had an English professor at Lake Forest College, beloved English professor, had her entire career there, and never married, no kids. She had a trust, and the trust was set up so that the college was going to receive basically the bulk of her assets. There was some stuff that was going to go to some nieces and nephews and so on, but the college was going to get most of it. And at the and her house was in Lake Forest. So if you don't know Lake Forest, think of mansions on the shores of Lake Michigan. It's one of the highest concentrations of wealth in the country. And so at the height of the real estate market, her house was worth probably $1 million. And she thought, okay, this is my most valuable asset. I'm going to give that to the college. So she wrote an addendum to her trust. And as the title said, she was a good English teacher, good writer, but a bad lawyer. And she knew nothing about trust law. So she wrote an addendum to her trust with no input from an attorney. And in this addendum, she said the college will get her house when she's gone. And she also said that this friend of hers, if she survives her, the teacher, would get to live in it for the rest of her life. So, okay, sounds kind of like a life estate agreement here. And the person living there will pay all of the utilities, but the college will be responsible for paying the taxes, the insurance, and any upkeep or repairs needed for the house. Well, when I showed this to the college president, he said, "No way, we don't have the funds to pay for all that. Who knows how long this woman is going to live?" She was in her 70s, so maybe she's going to live another 20 years. And it gets very incestuous. So the woman who got to live there was also an alumni of the college and one of the English professor's students, and they became fast friends. The woman who got to live there was also on the alumni board. and just happened to be a very outspoken and kind of cantankerous woman. And the executor of the estate was the retired president of the college. So, I mean, this is all very intertwined. So I gave this to our outside attorney and I said, is this a valid life estate or is this flawed enough that we could get a judge say that no, this is not right? And he came back and said, no, if you accept the house, you're going to have to accept it on these terms. So, which we clearly weren't going to do that. So, a lot of people would have just disclaimed the gift. But being sort of creative, I thought, well, what can we do here? So, I had our outside attorney figure out the actuarial value, life estate value of the person who got to live there and offered this woman a charitable gift annuity for that amount. Said, this is the value of your life estate, and we'll give you a gift annuity. You'll get payments for the rest of your life for this. And her attorney said, no, that's a bad idea. And I think the only reason he said it was a bad idea because he didn't have a clue what a charitable gift annuity was or didn't know what a life estate was. This guy was not fluent in tax law or charitable planning. And so finally, we made an agreement to buy her out for the value of her life estate in the house on the condition that she doesn't get that till we can sell the house. So, not a totally happy ending. It didn't do what the donor wanted to do, but we got out of it. I'm going to skip this one for the sake of time. I guess this is what the cloud looks like. This is a data center. Stephen Ross, billionaire real estate developer from Florida, owner of the Miami Dolphins, principal investor in Reary Holdings, a real estate partnership, and proud alumni of the University of Michigan. Well, Reary Holdings bought an interest in this data center for $2.95 million. And a year later, donated it to the University of Michigan. He had a $5 million pledge with the University of Michigan. And so we could get into the discussion of who can fulfill a payment on somebody's pledge, but that's a conversation for another time. So $2.95 million, Reary Holdings bought it for, gave it to the university. The university sold it about a year later for $1.94 million. And they had an appraisal done, of course. And if we were together, I'd ask you to guess what they claimed as a tax deduction. And most people would say, oh, probably the $2.95 million that they paid for it. Well, they claimed a tax deduction of $33 million and change. Well, the IRS suspected that this was tax fraud, that this was not legitimate, ended up in the tax court. And remember, I said the IRS now looks at the paperwork. So they looked at the appraisal. And remember, I said there are 11 different specific things that the treasury regulations say have to be addressed to make an appraisal a qualified appraisal. One of those items is what is the cost basis of the property, which would have been the $2.95 million. The appraisal left that line blank. It was not part of the appraisal. And so the tax court said, this isn't a qualified appraisal. You didn't address all 11 items. The cost basis is blank, so no deduction. And they also suspected that this really was fraud and called it a tax avoidance scheme lacking in economic substance. They always have an interesting way of wording things sometimes. So they lost the deduction, plus they got a huge fine, and the college still obviously got the real estate and the money from the sale of that real estate. So sometimes we just have to say no. And hopefully that's based on policy and not personal. Hopefully it's based on our good gift acceptance policies. And if it's unusual gifts, hopefully there's a gift acceptance committee made up of board and staff that are looking at this and making the decision not to accept it. But in my experience, I've found that oftentimes most donors have really good intent. They might just be really passionate about something that maybe isn't the appropriate thing to take money for, especially if it's like an endowment that's going to be there forever. And, I had a great example, an attorney friend of mine who was a very generous donor to Parkland Hospital, donated to the burn unit because as a child, he'd suffered a serious burn and he didn't live in Dallas at the time. So he was cared for at a different hospital, but he'd been living in Dallas for years now and supported our burn center. And we had a conversation and he said, I want to set up an endowment that will endow the burn camp that you do, where we would send children who were burn victims to camp every summer just to have a good time and to be with peers who had also suffered burns. And the reality is we didn't need money for burn camp. I mean, who doesn't want to support burn kids? We had more money for burn camp than we knew what to do with. So we didn't want an endowment for that. So I said to him, I said, Scott, you learned in law school that perpetuity is a really long time. So how about if we make the endowment just for general support of the burn unit and let the burn leadership decide every year what's the most appropriate thing to spend the money on? He said, "Oh, that makes sense." So sometimes we just need to redirect our donors a little bit and get something that is not quite as restricted. So I took a course on ethics, but everything was contradicted by the course I took on the history of tax legislation. We're going to end on that. We have about 4 minutes left and going to open it up for questions.
Yeah, we have several here. Nathan, if you want to jump in and kind of help me out with it. A lot of them have to do with appraisals, Kent. So Elizabeth would like to know, does a gift of software license require a qualified appraisal, or can the fair market value be derived from the list price?
It would need an appraisal, and any non-cash gift other than stock needs a qualified appraisal.
Yeah, we actually had an anonymous attendee, just kind of a question, and then again, with the disclaimer, Kent, you're not an attorney, but should a tax language be different if someone donates services like hours of gardening, in their example, versus someone donates a tea set from the 1800s?
So you can't deduct donated time to a charity. Um, I mean, if you incur expenses in being a volunteer for a charity, like mileage or some things like that, you can deduct that, but you cannot deduct time.
So no acknowledgement letter needed for that. Is an appraisal needed if a donor wishes to claim a tax deduction for oh, nope, that's the one we just did. So sorry. How would you get an appraisal for items over $5,000 that you donate to a place like Goodwill?
You would, before you donate the items, you would have to find a qualified appraiser who's familiar with the types of items that you're donating and have them do the appraisal before you make the donation. Yeah, that's a tricky one. I mean, but to meet the rules, that's what you would have to do. And this is interesting. Let me just interject here for a second. So much of this focuses on tax deductions. Yet with the new tax laws, about 0.2% of the people owe estate tax, and only about 12% of tax filers itemize deductions. So the reality is, with the new tax laws, we're talking about a smaller and smaller percentage of the population here. Anyway, I just thought I'd throw that in. Other questions?
I'm going to go to Aaron's because it's not related at all, but Aaron loves your email address. Uh, I was going to respond, Aaron, that's what you can have an email address too when you retire. You can have a unique email address.
Well, no, I've had this email address for years. I used to live in Key West, and I was involved with a nonprofit organization sinking a World War II ship for an artificial reef. So that's where Key West Wrecker came from.
Fantastic. Well, with that, we are out of time. We only have 1 minute left. If there's just a couple questions we didn't get to, you can reach out to Kent. Again, there is his email address, keywestwrecker@gmail.com. You can reach out to Nathan or myself if you have questions about Stelter and what we offer nonprofits. Again, we did record the webinar. We are recording it, so I'll offer the recording, the handouts, and the paper that Kent has written on this topic. I'll send you an email probably tomorrow. And you can also then find it on stelter.com/webinars. So thank you so much, everyone, for joining us today for the last hour. Kent, thank you for a very enjoyable hour and your experience that you've had over your 40 plus years. I know everyone really appreciated your time.
For those red flags.
Okay. All right. Thanks,
Thanks,
everyone, for
Ken.
joining us, and
Thanks all. What a pleasure.
we'll see you again next month for our next webinar. Have a nice afternoon. Bye-bye.